Hi, thanks for using My Court Coach. I'm Jaylyn, and I'm going to be your instructor as we talk about DV 100, which is the request for Domestic Violence Restraining Order. So, in order for you to properly complete this Domestic Violence Restraining Order, you would need to write your name, the name of the person that's asking for the protection, your age. If you do have a lawyer, then the name of your lawyer, the state bar number, the firm name, the firm address, the city, state, zip code. If you do not have an attorney, then you would need to provide your mailing address or your residential address. If you're trying to keep your residential address confidential from the other party, then you would only write your mailing address, the city, state, zip code, your telephone number. If you changed your phone number, you don't want the other party to have it, then you don't need to write the telephone number. Same goes for the fax and email. Those are information that is optional, but you do need to have a mailing address. Name of person that you want protection from. So your alleged abuser, you would write their information here. You have to know their gender, their height, their weight, their hair color, their eye color, their race, age, and date of birth, and their address. This address does not need to be known for the purposes of filing the restraining order, but you will need an address to be able to deliver these documents to the other party or to the restrained person, the person that you want to file a restraining order against. But you could fill this out to the best of your ability. If you don't know their date of birth but know their age, that's fine too. If you're not entirely sure what their race is, you can leave that blank. But at least having this information is helpful. And weight, of course, it's going to be approximate, so don't worry too much about that. But just to the best of your ability, you do need to describe this person. Now, do you want an order to protect your family or household members? And if there is individuals that live in your household, like roommates, for example, or your children is a great example, then those individuals would their information would be written, here. Now, when I say household members and I use the word roommate, this must be a person that does have some sort of familial relationship to you or your significant other. So if your grandmother is your roommate, then yeah, you would go ahead and include them. The court would prefer that if somebody that's not have like a family relationship to you or to the abuser, for them to file for their own restraining order. And it wouldn't be a domestic violence restraining order, it would be a civil harassment restraining order. So if there is something that is not related to them being like a family and the abuser and that person's not a family member, then you would not be able to protect them, or maybe you would on a temporary basis, but the court would prefer that that individual file their own restraining order to protect themselves. So you have to talk about or describe what is your relationship to the alleged abuser. And so you have to state whether you guys are registered domestic partners, whether you're married, whether you were married at some point, whether you were registered domestic partners, you currently live together, used to live together, you're related by blood, marriage, or adoption, and you have to specify what and how you were related, whether you guys dated at some point in time, or you used to be engaged to each other. If you're the parents of children together, then identify all of those children. And then if you have signed a voluntary declaration of paternity for the children, then the court would request that you do attach that as well. And if you don't know what a voluntary declaration of paternity is, then you're likely to not have signed one, but you typically sign it when the child is born at the hospital. So the voluntary declaration of paternity, if you do have it, then you would go ahead and sign it if you are not married to the abuser but have children together. So other restraining orders in court cases. So this is very important because the court wants to know whether you two have been involved in other restraining orders between one another. And so if you have, you're going to say yes. If you haven't, then you're going to say no. But if you do have a court order and it's currently in existence, because it has to be in the last 6 months, then you can go ahead and attach it. So do you or the other person been involved in any other court case that's not necessarily a restraining order? So if you both are going through a child support matter, then you would go ahead and type in the child support in the county and the year filed, and if you have the case number. And this again says if known, so don't worry about it if you are unable to provide the case number on these things. But the more information that you have, the better. And in fact, when you do have, for example, a divorce or a paternity action, then the court can consolidate, meaning they can combine the two cases together so that you only have one case where you're filing a restraining order or you're filing paperwork in support of your divorce or your paternity action under that one case number. So it's just to provide for judicial efficiency so that you can file everything again under one case number, and the court only looks at one case versus pulling up both of your cases at the same time, which inevitably will be related. If you had another domestic violence restraining order that you have filed, but it had expired or you dismissed it, you would want to go ahead and list that. If you had more than one domestic violence restraining order, then you would want to go ahead and list that too. So each case, so if you filed 3 restraining orders against somebody or against that party, then you'd want to identify all 3 on here. And if you need more space, then you can attach a sheet of paper and just write DV100 other court cases. Or you could use this MC025 and literally write, DV100 on here, and then type in the other court cases if you wanted to. So check the orders that you want. You always want to fill out 6 and 7, check off just about every single box. So you don't want the other person to harass you, attack you, strike you, threaten you, assault you, sexually or otherwise, hit you, follow you, stalk you, molest you, destroy your personal property, disturb the peace, keep you under any surveillance, impersonate you, whether it's on the internet, electronically or otherwise, or block your movements. You don't want them to contact you directly or indirectly in any way, shape, or form, including but not limited to telephone, mail, or email, or other electronic means. And when we say contact, like they can't contact the mutual friend of yours to talk about you, and they're actually talking to that person in knowing that that person's going to go and relay the information to you. And so it's like a way to contact you. That's how they are getting, I guess, under your skin and therefore violating the restraining order. That is one of the violations. So that could be something that you can address in court if it comes to that. But they can't, set up a fake Facebook profile and contact you on Facebook about anything that would be a clear violation of the restraining order. And then it also says that they can't take any action to obtain your address or location unless there's a reason that the court needs to do that. Unless the court needs to say that no, they can't actually in fact have your address or location. So stay away order, you ask the court for the person in 2 to stay at least blank yards away. That's typically 100 yards away, but sometimes you need to do 1 yard away because you and the other person live together, and the basis for your restraining order is that they're just sending you harassing messages. This is perfect or a prime example if you're going through a divorce action and you both have a residence together and there's no need for the other person to really move away or move out of the house, but they do need to stay away from you while you guys are in the house. And so you would maybe write 1 yard here for your home, or maybe you'd write 100 yards here for all of it. And then for other, you would write at least 1 yard away from my home, or 1 yard away while we're at home, something along those lines. So it's just going to depend on your specific circumstance. But essentially, you would need them to stay away from you, your job, your home, your workplace, your vehicle, your school. Every person that was listed in 3, which is all these individuals, and the children, or the children's school or childcare, and then anywhere else that you frequent. And it can't be like, the local Vons. They can't just stay 100 yards away from that, because it's not like you live there, not there the majority of your day, unless that's where you work. So, but some place that you like frequent, like your, if you have like a childcare provider's home in addition to the children's school, and you wanted to specify that address, then that's something that you could go ahead and write right there. Or your grandmother's address where the children remain for X amount of time, then you could also include that address there as well. So if the person listed in 2, which is your abuser, if they're ordered to stay away from all of these places, well, they'll still be able to go to their home, their school, their job, their vehicle. And if the answer is yes, then fantastic. If the answer is no, then you will have to explain why they're not able to get to any of those locations. And so typically this would be because like they can't get to their home, for example. So if they can't get to their home, then the court wants to know, well, why? And typically you would write, well, I am asking for a move out order given the physical violence between me and the other party. And so that would be an appropriate response. So you would then check off the box for a move out order, and then you would ask the court to order the person to move out and not return to the following address. And this is the residence that you both have together. And then you have to have the right to live at that address. It can't be that the address is in the other person's name, they paid the mortgage and everything, and you were just only there for, a few months at a time or something, but you really have no right to live there. Then you're not going to be able to remove that person from their own home. If you've been there for, a year or 2 years, and again, your name is not on the title, you're not paying anything to live there, then you don't have a right to remove that other person from the residence. And then you might need to do like a 1 yard stay away, or perhaps look into shelter options and not remove the other party from the residence. So guns or other firearms or ammunition. So if you believe the other person possesses guns or firearms or ammunition, then you need to write yes. If you don't, you say no. Or if you have no idea, then you just write I don't know. And it states right here that this person will be ordered to sell, store, with a licensed gun dealer, or turn into any law enforcement any guns or firearms that he or she owns or possesses. And there will be a firearm hearing to ensure that the party does in fact follow those court orders. Now, recording unlawful communications, that's always checked off. You always want to be able to record any violations that's made by the other party. So if you don't check off that box, then you're not going to be able to do it, because it is illegal to record people without their knowledge and or consent. But when you check this off, you definitely can do it in the context of a restraining order. So care for animals. So if you had any animals, then you could also list them as a protected, well, it's not really a party, but a protected possession. So if you are the sole person that possesses and cares and controls the animal, then you're going to ask the court to stay X amount of yards away. Again, it's usually 100 yards. And they can't take the animal, sell it, transfer, encumber it, conceal it, molest it, attack it, strike it, threaten it, harm it, or dispose of it in any way. And you are going to ask that the animals be with you because maybe you've always been the primary caretaker of the animal, or maybe because the other party had threatened to hurt the animals to get back at you. So you want to be clear and concise as to what you're going to write right there. And then child custody and visitation. If you don't have a child custody and visitation order, then you will be able to obtain one by filling out this DV 105, request for child custody and visitation order. If you already have a child and custody and visitation order, you will also need to fill out this DV 105, request for child custody and visitation form. So we will get to that form in a different video, but that is what you would need to check off if you do have children. Now, if you do have children and you don't want to modify the current existing orders and you're not listing them on the restraining order, then you would not check off this box or any of these boxes. For child support, I do not have a child support order and I want one. I have a child support order and I want it changed. Or you now receive or applied for TNF, welfare, CalWORKS, or Medi-Cal. And if you are requesting some form of support, then you would attach your income and expense declaration or a FL-155, which is a financial statement that is simplified. Now, realistically, the court is not going to order child support on a temporary emergency restraining order. Also, they will unlikely order it at your restraining order hearing. The court will hear from you at a different time as to your child support issue, or if you file a brand new, action like a paternity action or a divorce action, then the court will handle those issues at that point. But the court really just wants to focus on the restraining order aspect of your case. So if you are requesting child support, you should still check off the box and fill out the income and expense declaration form or the FL-155 financial statement. Those are rarely completed. It's usually the FL-150 form that is completed. So property control. So if you guys have a vehicle together and you want temporary use, possession, and control of that property because you're the individual that drives the children from and to school, from and to activities, from and to doctor appointments, you'd want to include that you have sole possession of that vehicle. Debt payment. So if there's like a credit card or something that's due, then you would ask the court to make that other person pay that credit card debt and state what it's for and the amount and the due date. If you two are married, then you would say that you are married to this person or you are a registered domestic partner with the person, and you ask the court to not allow that other person to borrow, sell, hide, or get rid of, or destroy any possession or property except in the usual course of business or the necessities of life. And you ask the court to order the person to notify you of any new or big expenses and to explain them to court. And so this is the biggest exception right here. So the usual course of business. So if they do in fact, have a business and you both are have assets or property related to that business, and they need to do any of those things like borrow or sell or well, they can't destroy it, but they can borrow or sell the asset for as part of your business, then you go ahead and take those measures, but they would need to notify you and explain it obviously to the court. And then for any necessities for life. So if somebody has to sell their painting that's worth, a few $1,000s in order for them to pay rent, that's a necessity for life, and that's something that the court would be okay with you doing. And same goes for the other party. If they had to sell a painting or sell a car or sell something to help pay for their daily expenses, like a roof over their head, food, gas, those sort of necessities, then the court would allow for that. And they would have to explain, or you would also have to explain why you did that, why you did take that action. And you should be fine if you are explaining that it is a necessity in your life. It's part of your day-to-day survival. Spouse support, if you are asking spouse support, then You need to also fill out this FL-150 form and check off this box. Again, the court is unlikely to order that at your hearing or even as part of your temporary emergency order, but you would have to request it specifically through a FL-300 if you are requesting it through your domestic violence restraining order request here. So right to mobile device and wireless phone account. So if you have a shared account with the other party and you only want possession of that account or that mobile device, then you would need to include that information on here and the number or the number of the child. So you would need to make sure that this phone number does in fact belong. This phone number or this account might belong to the other person, but it is your phone number and it is the phone numbers of your children. And so you need to have temporary use, possession, and control of the mobile devices and the numbers associated with it. So debt payment, if there's any debt payments that need to be made for a wireless phone account, then you would need to list the wireless provider, the amount, and the due date. And you also need to specify why you're requesting that this wireless phone account is listed. And I mean, a perfect example is, I need this line so that I'm able to communicate with our kids to be able to pick them up from and to activities. Transferring of the wireless phone account. So if you're asking the court to transfer the billing responsibilities and the rights to the wireless phone number to you because the account actually belongs to the other person, then you can go ahead and ask the court to do that. The court is going to, if the court does make the order, then the court is going to make sure that you're aware that you're financially responsible for the accounts. So any service fees and costs and connected to the phone numbers, you can be responsible for any other fees, and you have to contact the service provider to find out what those fees are and whether you're even eligible for an account. So you can't say that, oh, this mobile number and this device actually belongs to the abuser, but I want it all in my name, and then the mobile service provider cannot even accommodate that request even with a court order. So you'd have to make your new account or transfer the line in a way and hold you responsible. So you'd have to first communicate with the wireless service provider and see what kind of relief is provided even with a court order to be able to transfer the account. Now, insurance, if you want the court to make sure that the other party does not change any of the insurance or the coverage held for the benefit of you or your children or any of the person that's listed, then you could check this box right here so that the other person can't cash, borrow against, cancel, transfer, dispose, or change the beneficiary. So a beneficiary is, let's say you had a life insurance policy, you and your kids are on your wife's insurance policy, and she can any moment make those changes without your knowledge. And so you're asking the court to not allow that other person to do that, to remove you as the beneficiary, to remove your children as the beneficiary, and all you need to do is check off that box and the court may grant that to you. Lawyer fees and costs. Even if you don't have an attorney when you complete this and you're filing this and you don't have an attorney, but you might at some point in time in your case might hire an attorney. And in order for you to obtain attorney's fees and costs, you would need to check off that box and eventually complete this income and expense declaration form. So at some point in time, if you prevail on your restraining order hearing and you're asking the court to pay or have him or her contribute to your lawyer's fees and costs because you won your restraining order, then you would need to have this box checked in order for you to even obtain a order for lawyer's fees and costs. So make sure you check it off because you really never know whether you need an attorney or not later down the line. So payment for costs and services. So you're asking the court to pay the following. It could be your housing, you could pay for medical care, damaged property, anything that you want the court to order for the other person to pay. You just write who it's paid to and for what's the purpose. So housing, counseling, medical property, medical care, damaged property, and the dollar amount. So damaged property is in the course of the abuse, the abuser, punched a hole in the wall, and now you need to hire somebody to fix it. That is something that you could ask the other person to pay for. The batter intervention program. So there's a 52-week batter intervention program, and you have to show completion to the court. You can check that off as well if you want the other party to attend it. Again, this is not something that the court would actually order at the time of the hearing, but the court, if you make a specific request for it through an FL 300, then the court will entertain that specific request to ensure that the other party does go through an intervention program. And then any other orders that you are requesting from the court, and for the court to establish those other orders, you can absolutely request them here. So anything unique to your specific circumstance, you would request it in that box. Time for service. So typically you would have to make sure that the other party receives your request for the restraining order and the temporary restraining order and the notice for the restraining order hearing at least 5 calendar days before the hearing. But if you need more time than those 5 calendar days, then you can shorten it to 2 calendar days. And maybe one of the reasons why you'd want it to be 2 calendar days is because you know that the other party is evading service. They are trying to dodge receiving this paperwork. They know that you threatened to file it and you're likely to go through with it, and they don't want anything to do with you now, and so they don't want you to serve them, and so they're going to do everything in their power to try and not get served. And so without them getting served, you actually can't have a effective restraining order. Like, you'll have the restraining order, but it won't be effective because he does not or she does not have notice of the restraining order. So you just need more time to actually get it to them, whether it's at their job, their home, or one of their favorite hangout spots that you know that they're going to be at, and you just need more time to be able to provide that to them. Another reason is if they don't even live in this county, they live one county over, and so you just need more time to make arrangements to ensure delivery of the documents. There is no fee to serve the other party. So the sheriffs actually would be able to serve the temporary restraining order if it's granted for free. The court hearing, so the court will schedule a hearing on your request. If the judge doesn't make the orders effective right away, the court may still make orders after the hearing. If the judge does not make orders effective right away, you can ask the court to cancel the hearing. So description of abuse. So this is where you want to write the date of most recent abuse, who was there, how the person abused you and your children. If you needed more space, again, you could type in right here, DV100 and description of abuse in order for you to complete this part sufficiently. Did the person use or threaten to use a gun or any other weapon? If no, then you check the box no. If yes, then you're going to describe what they used. Any injuries, even something as emotional distress, that could be an injury. Any bruising on your body, you could also include that as well. If the police came, identify it. If there's an emergency protective order, then you also say yes, no, or I don't know. However, if you don't know what emergency protective order is, then more likely than not, you did not receive an emergency protective order, because those are issued by law enforcement. And if you did receive one, then you would know whether it protects you or the other person. So description of abuse. This is essentially any other types of abuse that happened, or history of abuse rather, and you can include here another incident of abuse. So the date, the time, who was there, how the person abused you. You can include all of that information on the DV100 where you label this recent abuse. And then Same questions about the usage of any gun or weapons, even a knife could be considered, or it is a weapon, and you could write that in there. Describe any injuries and whether the police actually came to assist you guys with this incident. Then other persons to be protected. So if you have your children on there, oh, my children should be protected because the other party committed these acts of abuse in the presence of our children. They were one room away and they saw the aftermath, like let's say that your shirt was ripped or something like that, and the children had like seen that. But the fact that the children are present in the abusive environment, regardless of whether they actually observed it or not, that's enough for them to be protected, at least on a temporary basis. And this could be for anybody, in the household, like your grandmother, if she lives in your household and you want her to be protected, you can list that as well. And if the other person has made any threats about the grandmother, then that bolsters your argument to have the grandmother protected. It's not a guarantee that every individual that you list in your household is going to be protected, but I think you should find comfort knowing that if your house is protected, the other person has to stay 100 yards away from your house, then you know that whenever your family members or your household members are in the house, they're going to always be protected. And if they feel that they need their own restraining order, because this is just not enough, they need it when they're out and about, then they could file their own restraining order against the abuser. If there's any attachments to the form, then you're going to name the number of attachments. So if it's just this one pager right here, then you're going to write that it's one page. And so the declaration, you're going to sign it under penalty of perjury under the laws of the state of California that the information is true and correct. Date it, sign it, and then if you do have a lawyer, that attorney is also going to date it and sign it. I hope this helps, and good luck.